Thanks, everyone. My name is Matt Weiss, and I am the chair for the Georgia Lawyer Chapter of the American Constitution Society for Law and Policy. I want to thank you for joining us today for ACS's Symposium on Voting Rights in the States. Before I turn the podium over to Thomas Saenz, I want to quickly thank McKenna Long and Aldridge for hosting the event today, and also an alumnus of the Georgia Lawyer Chapter, Katie O'Connor, for helping put everything together. We're really happy to have everyone here and joining us for this great event. Before we start, I want to provide a brief background on the American Constitution Society. ACS is one of the nation's leading progressive legal organizations and consists of more than 200 lawyer and law student chapters in 47 states and the District of Columbia. It serves as a gathering point for those with a progressive vision of the Constitution. It includes attorneys, academics, judges, and policymakers. To learn more about the organization, we have lots of informational materials out front, or you can also visit the website at www.acslaw.org. We have a number of members of the national staff in attendance today as well, if you'd like to learn more about the organization. Locally, the Georgia Lawyer Chapter of ACS serves as a focal point for the network of progressive attorneys and legal organizations throughout Atlanta and the state of Georgia. Our chapter is the source of regular programming on timely topics of law and policy at the state and federal level. And we have a very broad breadth of programming ranging on issues such as Georgia's Guns Everywhere legislation, the Supreme Court's recent decisions in Hobby Lobby and McCutcheon versus FEC, political influence in state judicial elections, education funding, just to name a few. And we touch on important procedural issues that impact the democratic process, such as the constitutionality of the filibuster, the impact of money in politics, and the judicial nomination process. Through each of these events, the Georgia Lawyer Chapter sheds light on important issues to create a community discussion with the ultimate goal of educating and informing Atlanta's progressive legal community. I want to quickly draw your attention to two upcoming events that we're excited to announce. The first is titled A Dead End, the War on Drugs and Its Impact on Minority Communities. That program will be a panel discussion on state and federal drug policy and how it disproportionately impacts minority communities. And that's going to be next Tuesday, April 24th at 6:30 p.m. at the Blackburn Conference Center at John Marshall Law School. Another upcoming event we're very excited about is going to be a reception honoring the new federal judges in Atlanta. We've already received confirmations from Judges Pryor and Carnes on the 11th Circuit, Judges May and Cohen in the Northern District, as well as Judge Abrams in the Middle District. So it'll be a really good event. That's going to be at Bondurant, Mixon, and Elmore on Monday, April 27th at 6 p.m. So turning to today's program, I want to introduce Thomas Saenz. Thomas is the president and general counsel of MALDEF, Mexican-American Legal Defense and Education Fund, where he leads the civil rights organization's 5 offices in pursuing litigation, policy advocacy, community education to promote the civil rights of Latinos living in the United States. Mr. Saenz rejoined MALDEF in August 2009 after spending 4 years in Los Angeles, Mayor Antonio Villagrosa's executive team as counsel for the mayor. He previously spent 12 years at MALDEF practicing civil rights law as a staff attorney, regional counsel, and vice president of litigation. He served as MALDEF's lead counsel in successfully challenging California's anti-immigrant Proposition 187. Mr. Saenz graduated from Yale College of Law and Yale Law School, and he's clerked for 2 federal judges before he initially joined MALDEF in 1993. So on behalf of the American Constitution Society, please join me in welcoming Mr. Saenz. Thank you very much.
Good morning. Good morning. I'm very, very happy to be here and very pleased to see so many people in the room for this timely and important topic. I do have to tell you, I am from California, and so it's actually 7 o'clock in the morning. I'm not sure that I have anything particularly insightful or profound to say today, so I'm going to take off my watch and make sure that I'm within my time, because when I don't have anything insightful or profound to say, and it's early in the morning for me, there's a severe danger I'll go way over time. But the reason I'm proud to be here, and I want to congratulate ACS for hosting this symposium, is that it is of course timely and topical given what we are facing across the country in the aftermath of the Supreme Court's decision in Shelby County. Now, we of course convene during the week that is the 50th anniversary of the introduction of the Voting Rights Act of 1965, and it is an irony and an unexpected development that we are having a deep and important conversation about voting rights in the states and under state law during a time when we should be celebrating the continued impacts of the Voting Rights Act of 1965, not only commemorating what was achieved 50 years ago through the pain and suffering of so many folks, particularly in the South, in trying to ensure that the federal government would take a strong role in securing initially and then securing over time the rights to electoral participation of African Americans and other minorities across the country. But a part of our commemoration this year has to be about what can be done as a result of what has been done by the Supreme Court majority in Shelby County. And that's the backdrop for the convening today. Of course, those of you in the room are fully aware, I'm sure, of what happened 2 years ago when the Supreme Court majority decided to effectively disable the most powerful section of the Voting Rights Act of 1965, one that I think justly has been cited over time as perhaps the most effective and powerful civil rights tool in all of federal law, that being Section 5, which required, as you all know, certain jurisdictions to subject any electoral change to a pre-clearance review by the Department of Justice or the U.S. District Court in Washington, D.C., to ensure that that electoral change would not have either the intent or effect of diluting or suppressing the rights of minority voters. And we know through the decades of successful experience under Section 5, not just in the South where it had its greatest application, but in other parts of the country, critical importance to my organization, MALDEF, like Texas. We certainly benefited from the fact that Texas has been subject to Section 5 preclearance. Arizona, we have benefited, the Latino community has benefited from the fact that Arizona was subject to preclearance, and 4 counties in California, which ensured that even statewide changes in California with the potential impact on huge numbers of Latino voters would be subject to preclearance review. So we know from experience how effective it was to ensure that changes being contemplated by certain jurisdictions would be subject to a review. We also know that when the Supreme Court decided that the coverage formula was unconstitutional because it picked on certain states, because it imposed a stigma on certain states. I always thought states were much more strong and willful than that, but the Supreme Court majority has told us they are sensitive souls and can't deal with the stigma of being identified as having somehow unequal sovereignty in comparison to their brother and sister states. But by striking down the preclearance formula, the Supreme Court effectively, at least temporarily, nullified the preclearance mechanism. Now, there is still hope, as I'm sure you are aware, and some of the folks you'll hear from later today are integrally involved in trying to ensure that even without a legislative fix, we can have preclearance applicable to certain jurisdictions through judicial order. But until we receive such a judicial order, or until the Congress chooses to act, we are stuck without Section 5 as a mechanism to prevent the kinds of attempts to suppress and dilute the votes of minorities that we increasingly see across the country. And of course, you are all aware of the efforts ongoing, and important as they are, in Washington, D.C. by coalitions of groups across the political spectrum to see that a bipartisan effort to react appropriately to the Shelby County decision and to enact a substitute preclearance formula, coverage formula, has had its own obstacles and barriers. Although we have seen now for 2 straight years the introduction with bipartisan support of voting rights amendment acts, it is quite clear as of this point that this Congress and its predecessor last year had no particular interest in moving forward in considering, much less voting on and sending to the White House, a Voting Rights Amendments Act. Now, that failure to even consider is, of course, a tremendous contrast to what we saw a mere 8 years ago when bipartisan supermajorities in both the House of Representatives and the Senate chose to reauthorize the Voting Rights Act and its preclearance formula only a few years later to see it struck down by the Supreme Court. So that is the context in which we are meeting in this 50th anniversary of the Voting Rights Act of 1965 to talk about how state law might step in, state constitution, state legislated statute, state administrative action might step in to begin to accomplish some of what previously might have been accomplished through preclearance. It's important to note that this is an effort that is nationwide, because while preclearance applied only to certain covered jurisdictions, it is also quite clear that preclearance had positive effects across the entire country, because it enabled us to know early and without tremendous expense or animosity in the course of litigation whether particular electoral changes were likely to have and were likely to be determined to have discriminatory intent or effects. That means, as a nation, even in uncovered jurisdictions, we had an early indication of what to avoid, an early indication of how legislation in the realm of electoral practices needed to conform itself to ensure that it would not result in the discrimination that the Voting Rights Act was designed to prevent. So we are looking today for substitutes. My remarks this morning are only to make two quick points as we begin that discussion. And that is to see this effort in Georgia, in the region, and indeed nationally as part of a coordinated response to Shelby County with an aim that is not directed solely toward addressing particular issues in particular counties, in particular states, or particular regions, but is really about influencing long-term where we end up as a nation. And I think we should see it in that framework because we have to recognize that despite the obstacles and barriers that a legislated response to Shelby County has faced, ultimately the nation requires uniformity when it comes to electoral practices as much as possible. And that means a strong federal role in protecting the rights of everyone to vote. So ultimately, these state steps have to be seen as interim, have to be seen as progressive toward a long-term goal of changing national federal policy in this arena. I want to say two things further about that, but I want to first give you some examples of what has been done in this realm that I hope many of you are aware of from California. In California, we have had now since 2001 a California Voting Rights Act. And that means that it was enacted even when the coverage formula for Section 5 was still intact. Indeed, it was not yet reauthorized with those bipartisan supermajorities that I mentioned earlier. It was enacted at a time when 4 counties, as I mentioned in California, were still subject to preclearance. But it was enacted through the efforts of MALDEF and a number of other groups, initiated by a former MALDEF president, a brilliant voting rights litigator named Joaquin Avila, who came up with a state version of the Federal Voting Rights Act for one primary reason. Because litigation under the Federal Voting Rights Act, separate and apart from the preclearance mechanism, litigation under Section 2 was so costly, so time-consuming and so resource-intensive that it was difficult to contemplate ever having more than a small handful of Section 2 cases going on at the same time within a region, much less a state, even one as large as California. And the daunting prospect of having to wait through so many Section 2 cases to change electoral practices in California is what led to this 2001 California Voting Rights Act, which basically streamlines the ability to challenge at-large election systems at local level in California. It has resulted in the ensuing 14 years in a cascading series of changes, most of them achieved through settlement of litigation, often before it's even filed. Because the cities, school districts, water districts, other special districts that are subject to the CVRA have concluded that by streamlining the process of challenging at-large systems, the legislation makes it no longer worth the effort to oppose. That is to say, they know up front that the major issue of concern, whether there is racially polarized voting, whether minority groups vote differently in general from white voters, that if there is evidence of racially polarized voting alone, that will suffice to secure their defeat in litigation. And they also no longer have the ability to engage in protracted, expensive litigation designed to convince the plaintiffs to compromise in order to avoid the cost and expense of going forward. The CVRA, as I said, has resulted then in dramatic changes in local elections in California. It is an example that there are attempts to replicate in Illinois and Washington State, but it is an example of an effort to ensure that by using state law, we can arrive at quicker and less expensive solutions to voting rights problems and controversies that otherwise would be in federal court under Section 2 of the Voting Rights Act, with the expensive proposition of having to prove a case under the operative test of totality of the circumstances. Now, you all who are in the legal field understand readily that if the judicial test is totality of the circumstances, you are looking at extremely expensive, extremely long-term, extremely daunting litigation to challenge any electoral practice under Section 2. Looking to build on the success of the CVRA, which I mentioned applies to challenges to at-large electoral systems at local level, California is currently considering two other implementations, two other pieces of legislation to address concerns, particularly in the aftermath of Shelby County. One would seek to expand the CVRA to apply not just to at-large challenges, but to challenges of already districted local systems where there is evidence of racially polarized voting. It would again, like the CVRA, substitute a primary concern with the existence of racially polarized voting for the much more arduous totality of the circumstances test under federal law. That's currently pending in the legislature. And the other would seek in California to implement its own version of preclearance. Now, this is a version that is not based on identifying specific sub-jurisdictions in California, but is based on a proposal that's also been considered and being considered, I hope, in Washington, D.C., that has come to be called known practices coverage. That is to say, the state legislation would identify specific electoral changes that have a demonstrated history around the country of being used potentially to suppress minority votes, and subject those specific changes, wherever they occur in California, to preclearance by the state through the Secretary of State's office. Some of the practices that would be subject to preclearance are things like reverting from a districted system to an at-large system, annexations, which have often been used to dilute the growing vote of urban minority populations. Annexations would be subject to this preclearance. Certain changes in precincts and polling places where there would be a disparate discriminatory effect on minority voters would be subject to preclearance, and similar matters. So that also is pending in the California legislature, and these are examples of attempting to use state law to respond to what the Supreme Court majority disabled, at least temporarily, in Shelby County. I think that these proposals and the enacted CVRA epitomize what I want to identify as two of our goals in this overall enterprise, hopefully more and more coordinated across the country, of taking incremental, interim, progressive steps toward influencing the development of federal law. First and foremost, and I particularly like to say this to crowds of lawyerly types, whether they're lawyers or those who hang around with lawyers perhaps too much. But one thing that I think we can use state law efforts to establish is not simply that there is a need to protect the right to vote. Those who are not convinced of that are unlikely to be convinced for their own political reasons, but to demonstrate that there is a shared interest in enacting efficient and effective mechanisms of addressing voting rights concerns. Indeed, I like to say that one of the things that the Supreme Court majority did in Shelby County, beyond disabling what has been justly described as the most powerful civil rights tool in federal law, what they also did, contrary to what they've done in other circumstances, as many of you know, is they basically struck down possibly the first alternative dispute resolution mechanism in federal law. Because we as lawyers, I think, should see preclearance as that. It is a way of taking controversies about voting rights matters, about the effects of electoral changes, out of the judicial arena, where again they would be subject to that totality of the circumstances test, that notoriously costly and inefficient totality of the circumstances test, and instead putting them in an administrative process, an alternative dispute resolution process, involving review by the Department of Justice and involving the collecting of views and evidence through a much more efficient process than litigation. Now I know that I'm onto something in calling this an alternative dispute resolution device, because when I spoke about this at the ABA convention this past summer, one of the lawyers who represented Shelby County repeatedly came back to it and repeatedly told me I was completely wrong. Of course, he gave no reasons. He just repeatedly had to say, no, it's not ADR, no, it's not ADR, no, it's not ADR. So I know that I'm onto something in saying it is ADR, and we should portray it as efficient and effective alternative to litigation. Seen in that way, then alternatives to Section 2 litigation are in the best interest not only of the plaintiffs who are seeking to vindicate the voting rights of minority groups and indeed of everyone within a jurisdiction, but also in the interests of defendants. And I think it's absolutely true that not only has the California Voting Rights Act resulted in changes in those at-large systems, it also has undoubtedly saved jurisdictions in California millions and millions of dollars. Because had those jurisdictions been subject to defending and ultimately losing and paying attorney's fees to the plaintiffs under fee shifting, every one of those jurisdictions would have faced a price tag in the millions of dollars. Add that up over all the jurisdictions, and basically CVRA has saved the state of California and its local cities and school districts and other special districts millions of dollars, literally hundreds of millions of dollars. Seen that way, what we're talking about today is a means of establishing to those Congress members, many of whom are blocking any consideration of the currently introduced bipartisan Voting Rights Amendments Act, to understand that there is a shared interest of plaintiffs and defendants in finding a more efficient and effective and less costly way of addressing voting rights concerns, of establishing through state law efforts that in fact we can arrive at efficient mechanisms of addressing these issues, and that those mechanisms are superior to the Section 2 litigation that is now occurring across the country, often in jurisdictions that previously would not have faced it because their changes would have been blocked or deterred, even if in an uncovered jurisdiction, by the application of the pre-trans provisions of the Voting Rights Act. So I think that part of what we have to be about doing is establishing that shared interest across the board, even with those who are in the position of defending electoral changes that all of us in the room, and indeed most courts, would conclude have a discriminatory effect, if not being motivated by discriminatory intent. So that's number one. And the second, indeed not even as unprofound as that previous, is simply that we are also, through state law, building models for what federal law should be. We can demonstrate through success applications that not only result in changes in voting rights practices to respect voting rights, but those changes are not threatening, do not result in widespread fraud. We all know that that's the notion of voter fraud is itself the biggest fraud in this area. But in fact, demonstrating through practice that the changes we are looking at doing and implementing do not result in widespread fraud, as we know that they will not, but can prove now with practice through implementation of state law changes. We are then setting a model for what the future should be. Now, I want to just append that by saying it is not only potentially a model for what Congress should do in response to Shelby County. Indeed, part of the reason that we in California are pursuing that pre-clearance mechanism for known practices is not particularly because we think that it's needed in a widespread way in the state of California, but to set a model for what Congress should consider as an alternative, indeed supplemental, coverage formula as it looks at a Voting Rights Amendments Act. But our model is not only for what Congress might enact, what we hope a future Congress would be willing to consider, then enact and send to the White House in response to Shelby County, but I think we should also see it as potentially an area where the courts might ultimately go. Put out of your minds that we would have this Supreme Court majority forever. I know that's something that we all hope and believe will sometime change. But assuming that that's the case, you know, I'm grateful that ACS gives us these constitutions always, because I, in changing recently from one briefcase to another, failed to include my pocket constitution with me. So here I have it, and lo and behold, it turns out, of course, that Article 4 of the U.S. Constitution has a Republican guarantee clause and guarantees every state a Republican form of government. Now, that has thus far been concluded to be non-justiciable, so we are left with using other protections, mostly in amendments, and targeted particularly at discriminatory voting changes, the 15th Amendment, as well as its successors that extended the franchise nationally to women and to those 18 and over. But we're left with those tools because the Republican Guarantee Clause has been thus far determined to be non-justiciable. But as I looked at the Republican Guarantee Clause, of course, I recognized that when I went to law school 20-some years ago, I was taught that the 10th Amendment was non-justiciable in a dead letter. I was taught that the Privileges and Immunities Clause was vestigial and had no effect separate and apart from equal protection. I was taught that the Second Amendment did not protect anyone's individual rights. Now, 20-some years later, law students are hopefully being taught that in fact the 10th Amendment is justiciable, that the Privileges and Immunities Clause does have application beyond the Equal Protection Clause, and that the Second Amendment, for better or worse, provides protections of individuals' rights as well. So there is no guarantee, so to speak, that the Republican Guarantee Clause will forever be viewed as non-justiciable. It is there as a potential protection of every person's voting rights, of establishing a uniform expectation of what Republican forms of government in the states means. And it is my hope and belief that through putting together a set of incremental and progressive steps spreading from one state to another, we can begin to establish a modern 21st century expectation of what it means for every state to have a Republican form of government. Clearly, that is an evolving term, because when it was adopted, we know what it meant. It meant that only white men with property could occasionally participate in the direct election of representatives. We've come a long way. I know that some of you in your heads are saying, well, we haven't really come that far if you're talking about white property men having all of the electoral power. But we really have come as a nation a long way, and there is an evolving sense of what a Republican government would be. And it is my hope that our work today and beyond in building a record of what states together, not all of them, but majorities of them begin to understand and believe are the basic elements of a Republican form of government, we might ultimately arrive at a point with a Supreme Court majority that would tell states, you cannot have voter ID. It is not consistent with a Republican form of government. You cannot have onerous proof of citizenship requirements on voter registration because it is inconsistent with a Republican form of government. Maybe we might even end up with a Supreme Court majority that would say you cannot require someone to register to vote more than a day prior to an election because it is not consistent with a Republican form of government guaranteed by Article 4 of the Constitution. So those are my messages today. Nothing profound, simply that these are important steps building toward a larger progressive goal of federal changes that would apply nationwide, and that in doing that we are at two things. First, establishing that there is a shared interest, including defendants' interests, in arriving at more efficient and effective means than Section 2 at protecting voting rights and at resolving voting rights disputes, and that we are evolving a shared national understanding of what are the basic requisites of a required Republican form of government in every state across the country, with a goal ultimately of implementation nationwide. So I congratulate you all for being here. I welcome you all, and I look forward to participating in the further discussion of this critically important endeavor. Thank you.